Thank you very much. Thank you very much, Anne. We're pleased to have Esther Kim and Jonathan Lee with us tonight. Esther has an estate planning practice in Martinez, and Jonathan works for the federal government and is also a board member of the ADR committee of the CCCBA as well. And it's a pleasure to work with you, Jonathan. They co-teach negotiations at Berkeley Law, and they're here tonight to present on the role of apologies in negotiations, what practitioners should know. So with that, welcome. We're very pleased to have you both, and we'll let you take it away.
Great. Thank you so much, Nathan. We're really pleased to be doing this program this evening because apologies are just such an important part of our practice as well as in our personal lives. And, you know, in our profession, we tend to focus attention on the glory parts of our practice, you know, the times we won a trial or dispositive motion or, you know, succeeded in a negotiation. But we really don't give very much attention to what can be one of the most important tools in the lawyer toolkit, which is the authentic, meaningful apology that is shared between two opposing points of view. And in fact, evidentiary rules discourage this type of apology to admit responsibility. But as we will discuss in our presentation, there are some signs that this is starting to change. And, you know, apologies, an effective apology can really have a big role in our practice. After all, what we do as lawyers is counsel and advise our clients. And, you know, the courtroom victory is just a small fraction of what we do for our clients. So in our role as counselors, we can help our clients identify and consider long-term interests rather than just the dispute that's at hand, and whether an apology can actually help the parties create a new way of interacting that would create value for both parties. You know, and this is particularly true where the client and the adversary have a pre-existing relationship. So the effectiveness of apologies is based on scholarship in this area by the Harvard Negotiation Project, Professors Fulberg and Robenholt and others. And we hope that you consider how the apology may be used in your practice. So let's begin. So when we talk about apologies in negotiations, what we're talking about are the professional negotiation where we as attorneys are representing clients in a negotiation, and also in the professional way in which we are discussing with our clients and counseling our clients in that negotiation process. And of course, the personal. We feel that these, you know, the topic of apologies is relevant across the board to each and every one of these situations. Next slide.
And I'm going to talk about some of the other parameters that we want to focus on tonight. You've heard already a little bit about the role of counseling. We just want to emphasize that, you know, much of what lawyers do in representing clients fits within counseling and isn't necessarily seen by anyone else or heard by anyone else. There is this this great thing that helps lawyers represent clients called the attorney-client privilege, so that clients and lawyers can speak to one another candidly about the task or the issue or the dispute that's at hand. And it's within this role as counselors that we're thinking that there isn't enough attention paid in our profession to how lawyers can help to shape outcomes for clients that may include the consideration of apologies in their lives and in their businesses. We also want to recognize the problem of reactive devaluation. A reactive devaluation is just one of the psychological traps or heuristics that we discuss with our students in our class. And we've selected it because it just seems to be so prominent in our world today. And what it is in a nutshell is people tend to devalue information that they hear based on a source. So the source of the information turns out to be the reason why we value it. Imagine a world in which people don't tune in to a cable news network because they just simply don't want to hear anything that's said on that cable news network. We're living in that world right now. We're awash in reactive devaluation in the United States. People will go to the source that they trust. And if they hear something from a different source, they just instantly will disregard it or discount it or give it no value whatsoever. And that's kind of driving a lot of our public debate and discussion. And it really applies to our representation of clients, because of course, clients that are in a dispute tend to not want to hear or give value to what the other side of the dispute may be saying to them. And we as practitioners need to understand this process and need to be able to talk to our clients about it in a way that may help them focus on the content of what's said rather than the fact that it's coming from their adversary. And to the neutrals and mediators and other providers out there, of course, you serve an important role as a buffer in being able to talk to parties and deliver messages to them that they otherwise may not be able to hear because of reactive evaluation as it applies to their adversary. So it's important to know that this is an obstacle to apologies across the board. And finally, we're just dealing with social norms and mores that tend to view apologies as perhaps signs of weakness or signs that you otherwise don't have a strong position, or just tend to not focus on apologies as creating a social good. How many lawyer resumes or websites have you seen where people are touting the ability that they were able to obtain an apology for a client, or that they counseled a client to give an apology? There may be a few, but it's probably a pretty small number, because we're focused on, as Esther said, these gladiatorial aspects of the profession. You know, we use terms like eat what you kill and, you know, one-on-one combat, a lot of combat imagery. Whereas the apology requires, when it's genuine and meaningful, it requires people to come together and collaborate around an accounting of what's happened between them in a way that they can both value. So let's talk about what is an apology. And we're going to cover this in a couple of slides. First, we're going to talk about the three essential components of an apology. And those three essential components are a statement of regret. And this should be an unadorned, no caveat statement that actually conveys a sense of regret. I'm sorry is the simplest and most direct statement of regret. A statement manifesting sympathy, and the idea here is that the person making the apology demonstrates to the recipient that they have been seen and heard in a way that recognizes that they've been harmed in some way. A statement admitting responsibility or blame. I'm sorry, that looks like it really hurt. It was my fault. That covers all three of those. And then the two extra credit concepts, and we put extra credit in quotes because depending on the situation, you may need all five of these to get a complete apology. And sometimes 1 through 3 will work. But the fourth one is statement of forbearance, basically a pledge to not repeat the conduct that led to the need for the apology in the first place. And a statement offering repair or compensation of some kind. And so there you have the the complete 5-part apology would be all 5 of those. And what we thought we'd do is give you an example that we think you can hear and remember. It's not from the world of the law. It's more of an everyday occurrence. And that's why we're using it, because it transcends our profession and touches everyday human situations. So it's a thought experiment. Imagine you're seeing 2 children at a playground and they both go to play on the slide. And this is a slide where you have to climb the ladder steps to get to the top so you can slide down, something we probably each of us did as children. They arrive at the bottom of the ladder and child one bumps child two. Child 2 falls to the ground and is hurt. Child one goes up the ladder, comes down the slide. Unbeknownst to child one, child two has been hurt. Child one walks back around the ladder to use it again, sees child two. 5-part apology. I am sorry. That looks like it really hurts. That was my fault. I won't do that again. When we're playing from here on out, why don't you use the slide first? So you've got, statement of regret, statement manifesting sympathy, statement of responsibility, statement of forbearance, and statement offering some form of compensation or repair. And thus you're gonna have a complete 5-part apology. 2 children on a slide. All right, I'll turn it back over to you, Esther.
Okay, so now that we've covered what the components are for an apology, we're going to talk about, and this is going to be actually sort of the main part of our presentation, are the issues and concerns that come up around apologies. The fact that apologies may or may not be accepted and some of the issues that come up. So the first one has to do with timing. And unfortunately, we weren't able to figure out a way to show you this clip. So I'm going to have to introduce it and tell you about the clip that we wanted to show you to illustrate this point. So during the pandemic, a friend of mine introduced me to Korean dramas known as K-dramas. And let's just say that I went down the black hole, and I've dragged Jonathan with me, and we have been watching a lot of K-dramas. And what's so compelling about them is that the format is a little bit different than US dramas, in that the episodes are each about an hour long, and there's about 16 episodes per show. So it really allows for some expanded storytelling and character development, and also allows for the exploration of societal issues and cultural sort of dynamics that are just really interesting. And so the clip that I wanted to show you has to do with this young woman. It's set in modern times, and she is working at a prestigious company. And for personal reasons, she needs this job, and it pays very well. But the problem is that her supervisor has been harassing her. And for 3 years, she's been absolutely miserable in this job because he continually makes remarks about her clothing, about her appearance, about what she does in her personal time, and making sort of innuendos about a boyfriend. And this is in a team of, several people, and she is in the minority in terms of there are more men than women. And because as I said, because she needs this job, she just takes it. And, as a reminder, while the laws in Korea have come a long way in terms of sexual harassment, they are definitely not, to the point of where we are in the US. But they're definitely making progress. And so she decides that she needs to stand up for herself because she knows she needs the job, and she wants to see if she can make the situation better. So she calls her supervisor out and talks to him directly and honestly and tells him, these are the things that you have been doing to me over the last 3 years, and it's been making me miserable, and I don't want it to go on anymore. And he says to her, okay, well, what do you want me to do? And she says, I want you to give me an apology in front of our team. So he said, yeah, okay, sure. So the next scene is where they are at this team dinner at a restaurant, and the supervisor is addressing the whole team, and the female character is looking expectantly to, for this formal apology. And he starts off by, it's the year end. He's talking about what a great job everybody did. He's toasting everybody. And then he looks directly at her and he said, oh yeah, about that apology. Okay, yeah, so it's all good. We're all good. So let's just toast out the whole year. And she cannot even believe that this was the apology that he, that was supposed to address her concerns. And in fact, it just makes it worse because then all the team members start talking amongst themselves. What happened? Why would he apologize? Did something happen? And one of the team members goes to the supervisor and said, you know, what happened? And he goes to the team member and said, oh, it's no big deal. It's all good. So this is just a really good example, I felt, of where timing of an effective apology would have done so much good in this situation and allow for both parties to be able to continue the relationship and have more positive interactions. But instead, the supervisor completely misreads the situation and he gives this very lukewarm, does not meet really any of the factors of an effective apology. And the young woman follows him after the dinner is over. She follows him back to the office. He's by himself. And she ends up roundhouse punching him in the nose and drops him to the ground, and she leaves the company. So, you know, the lesson learned here is that, you know, timing of that apology where she actually specifically requested an apology would have, you know, I think short-circuited litigation that is sure to follow because she was not heard, she was not acknowledged, and in fact, it was so insulting that I think it probably would have, you know, given her the confidence to just go ahead and sue. So timing's got to be correct. And early is often a good time to do that apology. In Jonathan's slide example, you know, the apology right after the incident happened was really an effective way to handle that. If it had been done much, much later, you know, maybe at that point, the children would have been like, well, either you didn't think enough of me to apologize at the time, or maybe they just forgot about it. So the only caveat that I think we want to say about timing is that you have to also remember that the parties need to be, the parties and the issues need to be right. In other words, sometimes when an incident happens, the feelings may be too raw. And if you try and force an apology, especially if it's not an effective apology with all the 5 parts, you may end up doing more damage than good. Okay, so let's move on.
Got a little freezing here.
Okay, well, the next issue has to do with partial versus total. And we have a little clip, meaning, does the apology have at least 3 of the parts that we discussed, or is it something less than? And so we have a little clip to show you that will help illustrate that point. You have to optimize the.
I'm trying to, yeah.
Listen, I just wanted to say that I'm really, 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 really so
sorry.
Yeah. Woo! I did it.
Okay, so that's an illustration of how this is not quite the total apology. And we're going to discuss how a partial apology can actually do more harm a little bit later when we talk about a study that was done comparing total apology versus partial apologies and the effect on accepting settlements. Okay, next, Jonathan.
All right. I'm going to talk about another issue or concern, and that's qualifiers and caveats. So the problem here is that, and you see this so much in the news, almost every day it seems you'll see an apology in the news, and there's usually some caveat or qualifier attached to it, which can have the effect of just negating the apology. The statement, "I am sorry for any harm that I may have caused," is a limitation because it allows for the possibility that no harm was caused. And it actually shifts the onus to anyone who was victimized by the conduct to qualify as someone who has been harmed, or else they're not covered by the apology. So it actually runs the risk of apology rejection. And in the playground slide example that I gave you, I intentionally set that up so that there was no caveat, no qualifier, just "I am sorry. That looks like it hurt. It was my fault. I won't do that again. In the future, you use the slide first." But you can imagine that in many situations, the conversation would happen differently. It would be, "I didn't see you. I'm sorry that I bumped into you." Even that puts a little space between the concept of responsibility and the idea that the person did something wrong, because it focuses on the fact that child one didn't see child two, which may in fact be true, but it dilutes the power of an apology to make that factual statement in that setting. And of course, examples in the news, just within the last month, as we were thinking about this program, I happened to be in the United Kingdom for a week, and the Prime Minister was trying to apologize for these garden parties while the whole country was locked down, filled with qualifiers. I can understand, I think his statement went something like this: "I can understand where people who were locked down in their homes for a year may have felt that what we did violated the rules, but I can assure everyone that this was a work function. I'm sorry." And there's just examples, it seems like every other day in the news where this comes up. And hopefully when you hear this, now that we've had this discussion and you hear these apologies in the news, you will quickly identify the problems with the incompleteness, the partiality, whatever it is with the apology. All right. Esther, you're going to talk about right participants.
Okay, did we not want to show the clip of Larry David?
Oh, what happened to the clip? Okay, hang on a second. I had moved it, but I don't see it.
All right, okay. Well, when we come across it, we'll play it.
It's part of our, to the audience, it's part of our technical issues.
Okay, so
Well, let me describe the clip real quick. Okay, so Larry David in a scene from a comedy show, Curb Your Enthusiasm, I think it's called, goes in to apologize to someone, and he says, "So this is me apologizing. It's about as sorry as I can get." And that's the clip. It's about 20 seconds long, and what it demonstrates is that he didn't have the subjective intent and didn't use the tone and demeanor, which we'll talk about a little bit more, that you would need to convey an effective apology.
okay, so now let's talk about having the right participants, having the right person make the apology. And this is really important when you have in a mediation, negotiation, that you have the person who represents the other side that has the power to make these decisions. And the case I'm going to talk about, you might have heard about it, involves a young college student named Scott Kruger. And he was a freshman at MIT, and he started school in August, and was ready to start off in his college career. And 5 weeks later, he was dead. And he died of alcohol poisoning that was the result of an initiation event at a fraternity. And this made national news. And the parents were, of course, absolutely devastated. And 2 years went by, and they sent a demand letter to the school saying that they intended to sue the school, blaming them for their son's death. And the MIT attorneys felt that they had a strong defense. And in evaluating the case, they felt that they would prevail on the merits. So legally, they felt that they had the stronger position. But the president of MIT, Charles Vest, he took a different view, and he decided that from the MIT institution's point of view, that it would be more harmful for them to take this very narrow view of the case, and felt that it was not in the best interest of the school, and was not in keeping with their values. So they decided to mediate the case, and it was a very contentious negotiation to get to the mediation. As you can imagine, the emotions of the parents were very intense. And there was a point in time where the parents were insulted because the president had not come up to them to offer them any kind of condolences. And he had not done so at the council, at the advice of his counsel, to not approach them. And so after this hotly contested negotiation, wherein they negotiated where the mediation was going to take place, who was going to be present, the president of MIT was required to be at all of the sessions, and he agreed to do so. And during these sessions, the mediator played a really critical role in being able to allow the venting of emotions. And back to that issue of timing, when the president signaled to the mediator that he was prepared to make a full apology, the mediator was the one who was able to bring the parties together, and the president gave an unconditional apology and said, "We failed you." And then he asked, I'm like getting emotional, like thinking about this. And then he asked, what can we do to make it right? And the mom was she was still so emotional. And the father said, what more can we do? He apologized. And it was at that point that there was this emotional sort of break, and the mediator recognized, okay, now that this has sort of broken the ice, and they were able to actually come to the table and work together, and they ended up with a settlement of $4.75 million to the family, with an additional $1.75 million to fund a scholarship that the family would administer. And unbelievable, but at the end of all of that, the family and the president hugged each other. And, President Vest did not have to make that apology. There is no court that would have required that of him. And yet he personally took it upon himself to be the representative, to be, to be the right person to make that apology, to telegraph the sincerity of that apology to the family. And I don't think that it would have settled without that. And, in the end, the school avoided, the litigation and the publicity that would have come out around that. And they were able to actually make something more positive and beneficial to the community with the scholarship. So I think that, when you consider about whether or not an apology is going to be appropriate, it's really important to decide who is going to deliver that apology and the message that it sends to the other side. Okay, next slide.
I'm going to talk about sincerity and genuineness, which we've already touched upon a little bit, but want to just explain our thinking on this, that a true apology needs to be subjectively and objectively genuine on both sides, bilaterally, in order for it to be effective and true. And when we say subjective, what we're referring to is that the maker of the apology and the recipient must actually mean what they say and use a tone and demeanor and approach that demonstrates subjective intent. And when we say objective, what we're referring to is that the words that are used represent to the reasonable person who would hear them and mean to the reasonable person the concepts that we've been talking about in an effective apology. So we have a clip that I am wondering if it's still here. We'll see. Many of you have probably seen the show The Office. So this is a very short clip from The Office. Okay, let me optimize.
So, as a disciplinary measure, he is going to have to issue a formal apology. Dwight, have you prepared your statement of regret?
I have.
Let's hear it.
I state my regret.
You couldn't have memorized that?
I could not because I do not feel it. Okay, everyone.
All right, so that little clip illustrates that it's a partial apology, that the words don't objectively mean what they need to mean for an apology to be effective. It's only a statement of regret of our 5 parts. And the subjective tone and demeanor and intention around that do not register as an apology. It's not sincere and genuine. So hopefully that illustration helps to convey our program. All right, we're going to talk now about oh, guess what? Here is the Larry David clip. Why don't I go ahead and show that? Thank you all for your patience with my tech skills.
I just wanted to apologize if I offended you or insulted you in any way. So this is me apologizing. It's about as sorry as I can get.
Okay, so we wanted you to see those clips. We're sorry you couldn't see the clip from the K-drama. I think what we should do is send out the Netflix title and like episode and scene number, Esther, later so people can go and see it and maybe get introduced to the wonderful world of K-dramas in the process, because they are amazing.
Jonathan, can I just add one thing? Can I just add one thing? If you go back to that clip,
yes.
What I think is so funny and telling about that clip is how many times have you heard somebody apologize in that very exact way? I'm sorry if, and then, that qualifier, if I offended you in any way. I mean, that's the Boris Johnson apology. And that ending qualifier just negates everything that came before it. And we so often see apologies done that way. So I think the more that you are attuned to what really is an effective apology, you will start looking and paying attention to what is an ineffective apology. Okay.
Yes, but I think even if you've never heard this program or thought about this in any great detail or read any scholarship, just at a gut level, when you hear that statement, I'm sorry if I offended you in any way, you understand that there's something there that's missing. I think most people hear that and they realize it's not an actual apology. So we're covering that and some other concepts because we think there's a lot of problems with apologies, and that's a big one, but there are other ones too. Well, we wanted you to, it's not just the concepts, we wanted to share with you some actual data from scholarship because some people, in the world of law, practitioners in our profession may need some extra convincing that there are benefits to be had here from the use of an apology. So Professor Robin Holt, who's at the University of Missouri Law School, did a study, was published in about 2005, and there are two parts to it. The first part involved a bicycle and pedestrian accident, and all the respondents had the same facts, they had the same understanding of the injury involved, and they received the same settlement offer. Now, what differed was in the control group, it was a settlement offer with no apology. And then in the there were additional participants in the study, and they had either full apology or partial apology for the variables there. So we want to share with you what happened. Oh, they also moderated or manipulated the types of evidentiary rules that applied. In one group, evidentiary rules protected the apology. In another group, evidentiary rules did not protect it. And in the third group, there was no rule described. Okay, so let's look at what happened. Esther?
Okay, so what's interesting is that the results of that study showed that when there was no apology coupled with the settlement offer, 52% of the participants accepted the settlement offer without an apology. So 52%, 43% rejected the settlement, and 5% were not sure about it. So then let's compare that with the next slide. Now, when you take that settlement offer and you combine it with a full apology, you see a much bigger increase in the acceptance of that settlement offer. 73% of the participants accepted that settlement offer, with a reduction of only 13.5% rejecting it. And what's interesting is that the number of uncertain participants went up by 13.5%. So the big piece of the pie of people who accepted the settlement offer did so in conjunction with that full apology. So then let's try the next slide. Now this, I think, is the very interesting part of the study. When that same settlement offer was coupled with a partial apology, the acceptance rate of the settlement offer went down to 35%. So we're talking about this 35% is less than if there were no apology issued. And 40% were uncertain. That uncertainty went up by a lot, and 25% rejected the settlement offer. So that partial apology, when we talked about earlier, total versus partial and how partial can actually do more damage, this study plays that out and shows that. So in this chart, you can see having a partial apology is worse than having no apology. And the full apology exponentially increases the rate of acceptance of the settlement offer. Okay, next slide.
I'm going to talk about the second part of the study. And in this part of the study, they examined the effect of a partial apology, but they manipulated two variables. One was the severity of injury, and the other was the clarity of responsibility. So the east-west arrow represents the severity of injury continuum, and to the right, it's more severe, and to the left, it's less severe. And the north-south arrow represents the responsibility continuum. To the bottom, responsibility was less clear. To the top, it was more clear. So if you look here in the lower left-hand quadrant, we put positive impact. This summarizes a lot of data, but in essence, the broad conclusion of the study was that when the injury tended to be less severe and it was unclear who was responsible, comparatively unclear, a partial apology was more likely to have a positive impact. On the other hand, where responsibility was more clear and where the injuries were more severe, a partial apology was much more likely to have a negative impact. And the study concludes that it likely has to do with the fact that when you have more severe injuries, there's a complexity of feelings around the injuries, and more is required to actually deliver an apology because there are complex issues. There may be not just the injury, but its impact on a person's work life or an impact on their family life. They may have a loss of consortium claim, or the children may be suffering, or there's more complexity to it. So a partial apology in that environment, especially where it appears that the person making the apology is responsible, is going to be likely to have a negative impact. It's a very interesting study. It was published in a law review, and we'd be happy to circulate that as part of the materials that we circulate. You may find it interesting. A lot of law review articles are more about law and cases and doctrine, but this is really, it gets into the data. It's pretty interesting. All right. Next slide. Oops. We're going to talk a little bit about the evidentiary consequences of apologies and some of the implications that come up. First of all, the general rule is that a statement where a party admits fault is going to be admissible as evidence in court. And that's true in most state regimes. It's true in the federal rules of evidence. Because it's admissible, lawyers tend to advise their client not to make a statement that would admit fault, seeing that as in the client's best interest. And to be clear, we're not suggesting that it's always in the client's interest to admit fault. We're just suggesting that, let's say right now, let's say that it's 1 in 10,000 cases where it makes good sense in the client's long-term interest to take a different approach and admit fault. We think that number should be higher. It should be, maybe 1 in 1,000 or 1 in 100. And we think there are opportunities being missed by our profession and by based on the advice that we're giving to our clients, by clients and by mediators and neutrals to try to identify these situations and help clients and parties, opportunities missed to create new value among people that previously have a dispute. But anyway, also, we wanted to point out that inadmissible statements can be severed. So, a statement that includes an admission plus some other statement, which we'll get into a little bit later, can be severed off. And so part of it is admissible, part of it isn't. This all changes when people are brought within the confidential mediation process, whether it's in a joint session, whether it's communicated in a mediation brief, probably not as likely, but as long as it's communicated within the process of the confidential mediation, then it'll be inadmissible. And we put down here in the bottom, this emerging rule. Colorado was actually one of the leading states in this, and they developed a statute that they refer to as the I'm sorry statute. And it allows that in medical malpractice cases, including arbitrations, statements by practitioners, doctors and other healthcare providers that they are at fault and that they're sorry are inadmissible. And so there seems to be a little bit of movement among states to create new laws that would allow and encourage statements of responsibility, statements of apology in certain settings. And here, of course, in California, we have Evidence Code 1160. These are two excerpts. It's a longer statute, of course, but these are two excerpts that kind of make the point. The first excerpt is identifying that a statement that relates to pain, suffering, or death of a person made to that person or to the family shall be inadmissible as an admission. And later, the statute says a statement of fault, however, shall not be inadmissible. And the legislature, when it passed the law, included in its legislative history some examples that guided the legislators. And one I remember was an automobile accident, and one driver gets out, runs over to the other car, and says to the driver, "I'm sorry. That looks like that was a bad accident. Looks like you're hurt." Okay, fine, covered by 1160. Second example, driver runs over and says, "I'm sorry, I didn't see you. I was using my cell phone." Second part of that statement will fall within the second excerpt here and be most likely considered a statement of fault and shall not be inadmissible. Oh, looks like we have one more clip, Esther.
This is
Did you want to
to sum it all up.
All right, let me do what I need to do here to optimize. Now this one is a little bit longer, and I think it's fair to say contains glaring examples of many of the reasons why an apology may not be effective.
Hello, Mr. Burglar. Going somewhere? But you can rob Mr. DJ. Well, I'm going to teach you a lesson. He just happens to be a very good friend of mine. Otto! He's going to be very pleased with me when he finds you all tied up and ready for the police. And don't call me Otto. To you, I am Mr. Ah! Oh, God. Oh, my God. I'm sorry. I'm sorry. I'm sorry. Please. I'm sorry. I'm sorry. I didn't know it was you. How could I know it was you? I mean, how could you expect me to guess? Stupid jerk. I mean, what the fuck are you doing? Robbing your own house, you asshole! You stupid, stiff, pompous English. Ah! I'm sorry. I'm sorry. Yeah.
All right, so obviously the subjective intent there didn't rise to the level of a full apology. The words used, he got one statement out that he was sorry, but it was punctuated by a lot of violence that tended to undercut the expression of regret. So not an effective apology on many levels.
Don't forget the qualifier. I
Oh, the
didn't
qualifier.
I didn't expect to see you. I didn't. How was
Yeah.
I supposed to know it wasn't you?
Who robs their own house? Yeah. These are defensive statements. Well, we've reached the end of the prepared material that we had. We hope that you found the discussion to be an illuminating one, an interesting one. If you're a practitioner out there and you are considering for the first time apologies, we hope that you will give it serious consideration and that your client's long-term interests may be served, particularly where they have a pre-existing relationship with someone, through an expression of a 5-part apology that includes a statement of repair. And if you're a mediator or other neutral, this may be more of a reminder than anything else. You've probably seen and witnessed good apologies and bad apologies, but some concepts to consider again. So we're happy to answer any questions that anyone has. Thank you for coming otherwise.
Jonathan, do you want to turn off and unshare your PowerPoint, please? And then we can see if there are any questions. Hello. Okay. Anybody? Give it a minute. That was great. My favorite apology is the Batman apology. I know. But you know, they were all good.
I'll tell a real quick story. The first time that I saw this concept play out, I had just joined the U.S. Attorney's Office. Let me just say I'm here in my personal capacity only, and nothing that I say is a view of the United States government. Okay, done. But I was new in the office in 2005, and at the time I was in the civil division, and one of the things that we do is defend medical malpractice cases brought against the government by veterans. And we had a case involving a gentleman who served in World War II, was definitely part of the greatest generation, served all over the Pacific in active combat, saw a lot of rough stuff in World War II, came home through the GI Bill, got a degree, started a local business, had a nice local business, started a family, raised a family. Fast forward to the early 2000s, he's quite an elderly gentleman, and he needed a vascular surgery. And he went to the VA. He went in for a surgery that, while it was a serious surgery, it should have been handled, fairly routinely. But he didn't make it. He died. And so his family brought suit, and there were definitely issues within the care that an expert witness would identify as something being short of a standard of care. So they had a case. The problem was, under the law of California, which applied, the microcap caps non-economic damages at $250,000. That's state law. And the economic damages in his case were zero, because the VA benefits pay for everything that you would consider an economic damage. So this family had lost their patriarch, and the most that they would ever see from this case is $250,000, which seemed really inadequate. So we went to the negotiation, and we decided that we were going to give them an apology. And my colleague delivered the apology, and I was the observer. And she said, we just want to say, on behalf of the United States government, the Department of Justice, the Department of Veterans Affairs, and everyone who was involved with the care of your late father, late grandfather, that we are sorry. That when his country needed him, he was there for his country. And then when he needed his country, it let him down. We're sorry. And then we communicated that our settlement offer was $250,000, and the negotiation was over right away. But what's important, I think, about that, and going back to the MIT example a little bit, is that what MIT did fit within the values of MIT, and they were aware of those values, and they acted on those values. And same thing with our little case. We did that because the veterans of this country are sort of in this special category, almost a special ward of the government, because it provides medical care for them for the rest of their life, if they choose. And that care should be good. And so the right thing to do was to, consistent with the values that are that we all would want to hold in our government, to make the apology and to offer the full settlement amount that was available under the law. So that was really kind of an eye opener for me. It was so powerful. And the family said, you know, thank you so much. That means more to us than any check that we could ever get from the government. So that was in 2005. And I can still remember getting chills when that happened. It was so powerful. So there's an example.
Great example. We have a question in the Q&A. Do you recommend having someone practice an apology with the mediator before it's made to the other party to make sure it won't do more harm than good?
Esther, you want to take a first crack at that one?
You know, I don't think that's a bad idea. And because tone and the delivery of an apology is so important that, you know, I think having somebody reflect back to you how that might be received, I think would be beneficial, particularly if that's something that you are really intending to use in the mediation because you think it's the right thing. And you certainly want it to be the best apology that you can deliver. So I don't think it's a bad idea. What do you think, Jonathan?
Yeah, I agree. I think it's a good idea. I think sometimes, you know, there's an element within apologies sometimes that people identify that tactically it's good to make an apology. And I think that shows. I think it comes through. And so you can screen for that. I'm thinking in business disputes, you know, in particular, although there is a human element in everything that happens in business, I think a lot of times the participants or principals tend to reduce it to the pecuniary issues that they face. And so the tone may feel a little tactical, and it would be good to screen for that because it won't be received the way that would be, you know, would be effective.
Thank you for that. No, yeah, go ahead.
I see a question. I think it's directed at my example. Would there have been this is from Peter Hamilton, I think. Would there have been an apology absent the damages cap? If so, how would it have worked to advantage of both the government and the aggrieved family? I will say that is the most powerful example of an apology that I can think of. And it's the one that kind of got me thinking about this because I had been in private practice and working for local government, and there was no consideration of apologies at all. So I remember it both because it was the first and because it was just so powerful. But then whenever possible after that, when I was the lawyer in mediation, I would state an apology. I would say something like, you know, we're here in mediation. One of the nice things about being in mediation is that we just get to talk to each other like human beings. It's not like when I took your deposition. And it's not like when we're going to be at trial, if we go to trial. So I want to take this opportunity and just tell you, as a human being, I can see how difficult this has all been for you. And I'm not talking about our defenses. I'm not talking about all of our legal arguments. I'm just trying to let you know that I see what you've been through, and I can see the effect on you. And I'm sorry that is where we are. Again, without affecting my arguments later on. We're stepping out of that now. We're in a different role. And I felt like there were a number of cases where that was both the right thing to do and the beginning of a conversation. Now, we often paid more than we otherwise thought we were supposed to pay. So I think it worked to everyone's advantage because we reached a resolution. It didn't mean that we got the case, you know, within the authority that I had originally forecast necessarily. So the other thing about apologies is that you have more long-lasting outcomes if there's been a genuine apology that's part of the negotiation. You know, one of the things that we want from negotiated resolutions is certainty of outcome. You want to know that you're walking away from this dispute, it's over, and you won't have to revisit it in 6 months or 12 months or 18 months. And that's where there's two things that can help with that. One is to make a concession toward the end of the negotiation. So the other side has the experience of winning an issue. But the apology can really also help both sides to feel like they can live with the terms of the negotiated agreement on a more permanent basis. And that's in everyone's best interest. So I hope that answered your questions, Peter. I'd be happy to talk to you more about it as well.
So there's a comment in the Q&A from Malcolm Scher. Wouldn't it be great if lawyers who insult one another in the course of litigating by saying things or not according reasonable accommodations could recognize that they aren't benefiting their clients, and that an apology in the course of negotiations might cause the other side and its client to be more willing to resolve the dispute? Also read a wonderful book called Damages by Barry Worth about an approach to settling a medical malpractice case. Thank you. Thank you, Malcolm.
I mean, I think Malcolm makes an excellent point in that, lots of people complain about lawyers until they need one. And then what they expect is the zealous advocate who scorches the earth in search of the optimal outcome for that individual person at the expense of anyone else. And I think we need to counsel people. I really do. We need to counsel people about, recognizing their long-term interests. We use, Esther, I'm thinking of the example in the family law case that we use in our class where it's a divorce proceeding and there are kids involved, and the husband really wants the stock from the bank and knows that custody and visitation are really important issues. So he takes a position on custody and visitation that is calculated to help his position on stock, because he can then bargain it away to his spouse. And he just does it so he can do better on this stock issue. And what we talk to our students about is when you're out there in the world and you're practitioners, what we want you to do is be able, again, you're within this privilege that you have with your client. You should be able to talk to them and talk to that person and say, figure out a way to raise for that person the idea that using your relationship with your children as a bargaining chip in that way may not be in your personal long-term interests. And, maybe from that, there's a conversation that can start. I did want to say, we've said that apologies probably are most aptly thought of in situations where people have a pre-existing relationship, and that's all about family law, right? But we also recognize that while an apology is probably something that would really help in family law, probably more in many other areas of substantive law, it's also probably less likely to occur because of the dynamics. Once people are in litigation, they've passed an emotional threshold in most cases that is probably going to stand in the way. It's beyond reactive devaluation. It's to a point where it's unlikely. And so we just wanted, for family law practitioners out there, we recognize your reality.
Yeah. All right, we're closing in on 6:15. I just want to thank you very much for the presentation. We got most of the videos in. I think that was great. And Esther, you did a great job of describing the absent one. So I'm going to go look that one up tonight myself. So make sure. And we'll get you some materials and some information on those Netflix shows as well. So thank you all very much. And everybody have a great evening and good night.
All right. Thank you.